The matter of Wayne Spencer. Judge, Mr. Spencer is charged with breaking and entering in the daytime with intent to commit a felony, putting a person in fear, attempting to commit a crime, trespassing, assault and battery, assault, and another charge of assault on the 17th day of June at Lowell. Judge, this is the matter where Attorney O'Brien asked for a 15-day screening for competency and criminal responsibility.
Not assessing a legal service fee, and you've had a chance to speak to Ms. O'Brien.
Yes.
Your Honor, I spoke with Mr. Spencer. I reviewed his carry, and I also reviewed the criminal complaint and police report. Mr. Spencer is 54 years old. He's homeless in Lowell. He originally did not want to speak with me. He yelled obscenities. However, he then agreed to talk with me. He denied a history of mental illness, psychiatric hospitalization, or mental health providers in the community. In speaking with him today, he presented with mood lability, in which his mood ranged from very sad to angry and volatile. Mr. Spencer denies thoughts of wanting to harm himself. However, he presented as volatile and reported thoughts of wanting to harm himself when he spoke with his attorney. Additionally, he expressed concerning statements as to how he may present towards others if he were placed in a jail setting. Therefore, it's my opinion that he is a danger to himself and others at this time and requires hospitalization. Mr. Spencer's comments about yesterday's events are irrational. Although he appears aware of the court process and those present in the courtroom, he doesn't appear to really have a firm grasp of the nature of his charges or the potential penalty to his charges. In my opinion, he doesn't appear to factually or rationally understand the case against him. Therefore, he's really unable to assist in his defense at this time. So I believe he'd benefit from further evaluation of competency to stand trial. Additionally, based on the irrational statements that he provided regarding the events of yesterday, he'd also benefit from further evaluation of criminal responsibility. Now, in terms of the level of security, based on the nature of the alleged events that took place yesterday, his current volatility, and the statements regarding his potentially being a harm to others, I think that he would be best served in the strict security of Bridgewater State Hospital.
You wish to be heard further on this?
No, I don't, Your Honor.
All right, I'm going to issue a 20-day evaluation for competency and criminal responsibility in view of the seriousness of these charges. You want criminal responsibility as well?
I
correct?
do, yes.
Competency and criminal responsibility, danger to yourself and others in Bridgewater. Do you want to be heard?
Yes, Your Honor. With respect to the criminal arraignment, the Commonwealth understands that the court is inclined to order that the defendant be sent for further evaluation pursuant to 15B at Bridgewater. Based on the nature of the allegations, the Commonwealth is filing a motion for the defendant's pretrial detention pursuant to 58A. I have discussed that with counsel as well, and what we had discussed as a potential possibility was that the court could find good cause to put over the 58A hearing until the 15B evaluation has been completed. That would obviously be outside the normal 3-day window for the Commonwealth or the 7-day window for counsel. So the court would need to find good cause in order to do so. But if the court were inclined to do that, the Commonwealth would be content to go forward with the hearing after the 15B evaluation has been completed. The defendant does not need to be competent in order to go forward with the 58A hearing, but if the court is inclined to do so.
Do you stipulate to probable cause?
I do, Your Honor.
So there's probable cause that the offense, which is a qualifying offense for the purposes of 58A, occurred.
Yes,
The
and that
issue
would be
is
with
what?
respect to counts 1 and 2, Your Honor, the breaking and entering for a felony with a person in fear being a felony containing a substantial threat of the use of force, and count 2, attempt to commit a crime, that crime as alleged being kidnapping, again being a potential felony involving the threat or the use of force. I'm happy to give a recitation of the facts just for purposes of probable cause.
If you want for the record, you may.
Just for the record, Your Honor, the allegation in this case is that on June 17th of 2018, the police responded to a report of an individual who was attempting to kidnap 2 young girls. Upon arrival, the police spoke with witnesses on scene. They learned that the unknown white male, who was not known to the parties at the time of the incident, had been walking towards 2 young girls. He was observed standing behind a tree, looking at the girls. The girls were frightened by this. They turned to go back into the house, at which time the defendant before the court followed them into the house. The 2 girls ultimately took shelter behind the mother of one of the children. The defendant tried to push the mother out of the way in order to continue towards the two children, reached and was trying to grab the two girls. The mother was ultimately able to push the defendant out of the front door, at which time other individuals pursued him and a struggle ensued. He got free and began to run up Court Street before ultimately civilians on scene were able to get him under control for the police to arrive back on location. Based on those facts and circumstances, Commonwealth submits that there is probable cause to believe that there were two felonies involving the potential or attempted use of force, which would qualify under the statute for a dangerousness hearing on this matter.
I do find probable cause and no participants have stipulated that. And, Mr. Spencer, you're going to be held for an evaluation at the hospital. And in addition, the 58A will be scheduled, 58A hearing will be scheduled upon his return from the hospital?
Yes, Your Honor. And the only other matter that the Commonwealth wished to raise with the court was with respect to impoundment redaction of information pertaining to the juveniles who were the alleged victims, based on the fact that this was a crime of stranger violence with respect to those individuals and the fact that they are under 18 years of age. The Commonwealth is moving to redact their information from both the public and particularly from the defendant, given the nature of the allegations, certainly not from counsel, but just from the defendant and the public.
Attorney O'Brien, do you have any objection?
I don't.
So the juvenile's name and information.
Yes, please.
So, I do find as indicated probable cause for the 58A dangerousness hearing will occur, be scheduled upon his release from Bridgewater Hospital, correct?
Yes, Your Honor.
And the commitment is tentatively now is 20 days.
July 6th.
Thank you.
And how long are we redacting for, Judge? They said 10 years.
10 years.
We're doing 10 years.
How old are the children? Do you know?
It's based on the age, Your Honor.
How old are they?
It was a nine-year-old was the youngest, I believe.
It has many names. There's several names in there.
I think it's 9 and 11.
Right?
Yes.
All In this matter, sir, you're now being held without bail under 58A. You also stand committed under Chapter 123-15B to Bridgewater State Hospital for competency and criminal responsibility. The matter is now continued to July 6th, and Judge, we're putting it on for a 58A hearing.
Shall we plan the 58 year or schedule it at that time?
If we could put it on for the hearing, Your Honor, I will get the necessary exhibits together to be prepared in the event that we do go forward at that time. And as indicated, even if the defendant were to be found not competent, we could still go forward with the 58.
I do think it's agreeable that if he's not competent, he can still proceed. So I'll schedule it for July 6th.
The matter is now continued to July 6th for a 58A hearing. Sir, if you get arrested or charged with any other offense during the pendency of this matter, your recognizances could be revoked and you could be held without bail up to a period of 90 days or to the day of trial for good cause. Mr. Court Officer, there's a commitment met and a Bridgewater met. He's to go to Bridgewater State Hospital. Custody, Mr. Officer.
Thank you, Your Honor.
I didn't understand.
I'll see you on the 6th of July, sir. Your lawyer will go down and speak to you.
Okay.
That's okay. She'll spot speak to you.